please pose any questions you may have in the chat area. We will get to those either during or immediately after the webinar, or you can Twitter or email Connect First. At the bottom of the slides, you can see their information for their Twitter account and their email account. And we will go to our next slide. The agenda is improving compliance management. 2 is TCPA regulations and recent developments, PCI and TCPA best practices, and questions and answers. Our presenters are Jeff Brown, Nick Whisler, and Jeff Mina. Improving compliance management and making you more secure. The presenter is Jeff Brown, Director of Business Development at Compliance Point. With 30 years of IT experience and more than 12 years experience in the compliance and security, Jeff and the Compliance Point team assist BPO and call center organizations achieve and maintain compliance with industry and regulatory standards such as PCI, DSS, HIPAA, SSAE, SOC2, and more. Now I will hand this over to Jeff Brown.
Thank you for the introduction, and I appreciate everybody joining us today. What I wanted just to briefly go over today is some of the challenges that organizations in your industry and many other industries are having right now, and it's the fact that they're getting inundated with regulatory and industry compliance requirements. We're seeing that, not just in the FCC and FTC areas of TCPA, but you're being asked to comply with industries areas like PCI, regulatory areas such as HIPAA. A lot of organizations are really starting to get focused on requiring things like the AICPA's SSAE SOC 2 requirements, and then from a global standpoint, the ISO 27001. The huge challenge is how do you staff and organize and be able to manage all of these different regulatory requirements and still, obviously maintain focus on your business. In addition to that, a lot of these regulatory requirements are now just coming out with new versions. PCI has just released their 3.0 version. It requires additional requirements, additional reporting and efforts to meet those requirements. The Omnibus has just released one for HIPAA, adding additional requirements, particularly in the area of third parties and what we call business associates. Version of NIST from a federal standpoint is a new standard, and again, I'd mentioned there's a big push for SOC 2 for a lot of service organizations. On top of all that, we're seeing a tremendous increase in the breach. We see every week now we're seeing multiple breaches, in both from a financial or retail aspect, healthcare, just about all industries. And again, on that, there's a tremendous increase in the number of types of attacks. The hacking and malware is continuing to increase over the last year or so at a fairly high clip, and we're seeing more from the social engineering side now too. And of course, the mobile technologies and how these new technologies are evolving are just causing more areas where potentially things could happen. Not maintaining your compliant posture has negative implications to your security requirements too, because not doing a lot of the mandatory or regular activities required by these programs can also actually lead to breach scenarios. We're seeing also just a more exposure for organizations for these non-compliant areas. We're all familiar with the fines, whether or not it's TCPA or PCI, but in addition to that, you'll see things from PCI such as increased transaction fees. The credit card companies will even go as far as actually revoking the merchant's ability to actually utilize credit cards as part of their business. That obviously will have a ripple down effect to any service organization that gets breached, that impacts the merchant's ability to use credit cards. Obviously is going to have a negative effect, and more importantly may cause the loss of a critical customer. It also, things like not doing your vulnerability scans, not doing a lot of the basic, like I said, required activities that these uh, different programs require, will make you susceptible more to breach issues and that. And of course, that also results in impact in your reputation. Nobody wants to be on the front page of the newspaper or on the press. And the last one, of course, is it also may impact you from a civil action issue. So the whole idea about this is looking at compliance requirements and security the same way you would look at liability or disaster insurance, that there's a risk over here and you need to figure out a way to mitigate that risk. So typically what we see with most organizations is compliance from the way that they're addressing it is, we call that the annual fire drill, where you'll see organization marshal a group of people together, quickly trying to gather and scramble to get together the required information that the auditor is going to need. And in a lot of situations, they're actually creating it on the fly, just to make sure that they're when they do the findings, that it won't look so bad. The problem is that there's a tremendous uncertainty up front whether or not what your result's going to be and how that's going to look, even if you're doing it from a year over year, since if you're not touching or looking at this from the point in time where you get the initial certification to 10 months later, there's a lot of dynamics in organization that can change things, and not really knowing kind of where you stand puts you kind of at a disadvantage. And additionally, there's the dynamics of an organization where people come and go, roles change. It creates knowledge vacuums in how you've implemented a particular control one year. Again, you may not have that individual in place to be able to explain that, and now you're trying to figure out kind of how did we do that last year? Where are the documents that related to that? And the costs are increasing as well, both from an infrastructure standpoint as well as just actually the amount of effort to do the assessment. What a program should look like is basically compliance should be basically part of your daily process. It needs to be ingrained within the organization's culture, and everybody needs to know their role in the compliance and how they're securing their customers' information. There also need to be a set of control, again, a framework that maps these controls to the various regulatory and compliance issues on that. There really are three different approaches to that are out there right now, how we look at compliance. The first one is where typically we see with PCI and with HIPAA and a lot of these, where it's a point in time. You're being assessed at a point in time whether you're compliant or not. And unfortunately, what's happened is that it's the mandatory requirements that these programs are requiring you to do, from whether it's daily, weekly, monthly, quarterly, aren't getting done or being pushed aside because these people are wearing multiple hats and they're just not getting to it. The audit preparation time is usually fairly heavy, as I mentioned, and again, you run the risk where at the end of the year, when it comes up again, you've got a lot of additional effort that has to be done because it hasn't been identified. Programs like SOC 2 have implemented a period at a time approach where after you get compliant, there's a period of maybe 3 months or more that these controls are tested. So we determine whether or not they're staying compliant for that period. However, again, if you're not doing the things beyond that, things will get out of compliance. Your visibility to your level of compliance goes away, and again, you're just subject to surprises, and unfortunately, nobody likes those. The model that we really promote is more evolving to what we call a continuous model. These are where the regulatory requirements are mapped to specific standards. A framework is in place so that these standards are mapped to eliminate redundancy of the various controls across the different programs that you're supporting. There's a automation or a platform tool that goes in there to automate things such as assignment of tasks, notifications, escalation, that when things aren't getting done, automatically flagging that as a non-compliant activity, and be able to provide you with real-time monitoring. So on any day, I know exactly where I stand with each of the programs that I'm trying to manage. This continuous program really makes up three areas, what we call control, validate, and attest. Where control basically is we define that framework, you identify the requirements, who owns each individual control, you implement and create your control methodology or how you've implemented that control, and that's documented. So next year, you don't have to rely on the guy that put it through last time. It's there, it's written down, this is how we did this. It also keeps the auditor focused because that information is readily available to them. And then validation comes up. In addition to that, the result of this first piece is that you'll get your remediation. If there's any controls that are missing, those will be identified very quickly, and at that point in time they can be addressed. Once that is completed, we go into the ongoing continuous validation, where as controls will be validated, the auditor will review any evidence, and if the evidence does not meet the requirement, the internal auditor or a person will be notified that particular activity wasn't done to meet the standard, and it will be reassigned to the control owner. The attestation, of course, if this is PCI or say SOC 2 where there needs to be an attestation, once everything's completed, the attestation report will be provided as validation that they're meeting the requirements. And again, year two, as year two comes in, that becomes easier because everything's done. There is no large event going into the second year on that. One of the things I did mention is there needs to be some kind of technology in the middle to automate the process, because obviously one of the things we want to do is reduce the amount of effort and as far as knowing what's going on into the compliance program. So having some kind of technology to be able to give you the visibility of where you are with the compliance, automate the assignment of those controls, generate the notifications to saying you have an activity that needs to be done by this, being able to provide notifications and escalations when things are not getting done in time, and being able to provide immediate feedback to the parties involved. Really what we're talking about as benefits is giving you advanced knowledge, knowing that as you go into a program, whether it's PCI or TCPA or SOC 2, that you will know before that auditor comes in that where you stand and that you're going to be able to pass these audits. Gives you a kind of a reassurance that again you have what you've got, what you've got in place. Also that you're secure, as since most of these standards are based on security standards, that you're doing a lot of the things you need to do to ensure that you're protecting your customers' data the way they're requiring you to do that. And real-time assurances, if your customers or business partners are looking for assurances at any point in time that you're meeting those requirements, you've got something you can put right in front of them that says, yes, currently right up to date, here's where we stand with this particular standard, and you give them the level of assurance. And then a reduction of effort and time. What we're seeing is that you can save, depending on the size of your organization and the amount of resources in your compliance teams, you can save anywhere from one equivalent to one to multiple FTE folks as far as how much time and effort you're having to spend in managing your audit process. Again, what we do is we like to say this is a holistic approach because it really is an ongoing process. It gives you continuous basically a relationship between your audit teams and your IT organization and your security groups. It provides you with a centralized focus, so all of your data, documents, activities are in one area and can be managed and maintained. And it provides you with some way to eliminate a lot of the redundancy that occurs along a lot of these programs. And I guess the big thing is it will allow you to reduce some of the cost and effort around it. Again, if you've got any questions regarding the process or how that would work with your organization, I would be happy certainly to, sit down and discuss with you kind of how that program would work and whether or not it would be something that you'd want to implement into your operation.
Hi all. The next portion of this webinar is the TCPA Enforcement and Recent Developments. Our presenter is Nick Whisler from McMurray, Peterson & Schuster. Nick Whisler is an attorney at the law firm of McMurray, Peterson & Schuster. Nick's practice focuses on assisting clients in highly regulated industries, including the customer engagement industry, comply with federal and state consumer protection and privacy laws and regulations. Nick is a certified information privacy professional and currently serves as legislative chair of the PACE Ohio Valley Chapter Board and co-author of the PACE Regulatory Guide.
Thanks, Lisa, and thanks everybody for attending. Just to give you a quick rundown of what I'm going to talk about today. First, I'm going to dive a little bit into the state of TCPA enforcement and litigation, just kind of what we're seeing, what's out there. I'm going to give a high-level overview of the TCPA rules on calls to cell phones. I think a lot of people on this webinar have probably already attended one of the webinars that PACE or another organization have done in the past on that issue. So I'm not going to spend a lot of time there, but I think it does set up nicely some of the recent developments that have happened in the courts, and just kind of gives a little bit of background there that will be useful, I think, for everybody. So, and then lastly, we're just going to talk about kind of the takeaways and what we should be thinking about based on the most recent developments and how you can stay out of trouble. So, with that, the one thing I can say is that we are just continuing to see an increase in TCPA class action lawsuits. It's risen every year for the past 5 or 10 years. This year is no exception. I would say that, we're probably seeing 4 to 5 lawsuits being filed a day. It's something that we monitor, and the volume is pretty staggering. So the other kind of unique thing is that the FCC has become more aggressive. So in the past, at the federal level, the FTC, which enforces an entirely different rule, but it was very aggressive with its enforcement under the telemarketing sales rule. But the FCC did not really get very active in terms of enforcing TCPA regulations. It was mostly just left up to private litigants in the courts. It's starting to change a little bit. There's a couple fines that were levied. We're going to talk about that here in a minute, but kind of something interesting to note and just to keep an eye on moving forward, how active they become. As far as the common legal issues, most of the things are the same. It's calls to cell phones, text to cell phones. That's probably the #1 area. We're still seeing pre-recorded message lawsuits, do not call lawsuits. One that's not listed here, but we're also still seeing, if you can believe it, is faxes. So we're still seeing some fax lawsuits making their way through the courts. But probably more importantly than that are these substantive issues. What are the types of things that are getting people in trouble? It's primarily the lack of consent for a certain type of call, or that the scope of consent that they have is not sufficient for the type of call that they're making. So that could pertain to any of those legal issues that I just mentioned in terms of cell phones, pre-recorded messages, DNC violations, etc. But it's just the lack of consent. The other big issue, and this is probably the hottest issue right now, is the use of an automatic telephone dialing system, or what I'm going to call an ATDS for the rest of my presentation, to call cell phones. So a lot of developments there. We're going to talk about those. Reassigned numbers is another issue that we'll talk about when you're trying to reach one person, but actually you end up reaching another person because the number has been reassigned by the carrier. Failure to honor DNC requests. Still seeing a lot of lawsuits where people said, I told you this company not to call me on this date, and I received this many phone calls after that date. And then also some issues related to whether a call is considered a telemarketing call or a non-telemarketing call, which of course there would be different rules that would apply to those types of calls. So, this slide here is really just a list of sample settlements that we've seen so far this year. This is not an exhaustive list. This is just a sample, and it shows the range. I mean, you've got some in the low millions all the way up to the Capital One settlement recently for $75 million. So you can see the big banks at the bottom with the higher fines, one, because they have more money, and two, because of the number of calls for those lawsuits was pretty high. So just kind of give that out there. The two I kind of want to point out, though, are the ones I mentioned earlier about FCC, and that's the dialing services and the Sprint fines. So you can see that the FCC has actually been a little bit more active this year than they had in years past, and it's something I think to monitor as we move forward. I mentioned that we're seeing like 4 to 5 new lawsuits being filed every day, and these are primarily class action TCPA lawsuits. Here's a list of just some of the companies that have been sued. This is kind of more of the brand name companies. I don't want you to get the wrong idea. I don't want you to think that it's only large companies that are being sued. These were chosen primarily just to kind of give you an idea that it's every different industry and kind of ones that you might recognize, but it is smaller companies as well, medium-sized companies. It's not just Fortune 500 companies being sued. The other thing I kind of want to mention is that some of these companies actually have 2, 3, 5 lawsuits pending against them. So once a company gets hit once, it's not uncommon to see them hit with another lawsuit, which is obviously something that we want to avoid. With that, again, a little bit of background here on what it is, what the rules are for calling cell phones. Like, that's the #1 area that we're seeing lawsuits right now. Obviously, the rules just changed last year, but in general, the rule is that you can't use an ATDS or a pre-recorded message to call a cell phone unless you have the called party's consent. And as of last year, there's now 2 different standards, one for a non-telemarketing call and one for a telemarketing call. So for a non-telemarketing call, you just need prior consent or prior express consent. And as of last year, you now need prior express written consent for a telemarketing call. Primarily today, we're going to talk about what an ATDS is and the developments there. What is prior express consent for a non-telemarketing call, because there's been some recent developments there. I'm not going to spend a lot of time talking about written consents, only because there hasn't really been any case law guidance there. The rules are pretty much what the FCC enacted last year, and there's a few kind of points here worth going over, but I'm not going to go through the requirements in detail just because we don't have any case law on that yet. It's going to take time for those new standards to get through the court system to get some case law. So with that said, just be aware that you are allowed to get an electronic signature for this written consent standard. You do need to meet specific requirements. I think, one of the counterintuitive things is that somebody saying, and even writing and signing a piece of paper that says, yes, you can call me, is not necessarily sufficient written consent. There's specific disclosures that you need to use, that you're going to be using an automated dialer or a pre-recorded message if that's the case. Some other disclosures that need to be made. So just know that when you're getting consent, you need to set that up properly. And then also that mixed purpose calls are treated as a telemarketing call. So if it's a sales component combined with maybe a customer service component, that is going to be treated as a sales call. So with all of that, the other thing to keep in mind here is that all of these consent requirements, both the lower level prior consent, which we're going to talk about here in a minute, and then the written consent standards only apply if you're calling cell phones using either an ATDS or a pre-recorded message. If you're not using those technologies to make these calls, then you don't need consent. at least not at the federal level. So again, that brings up the question of what is an ATDS exactly? What type of technologies would be considered an ATDS to bring us within the scope of those consent rules? I've included the statutory definition here. It's equipment with the capacity to store or produce numbers to be called using a random or sequential number generator and then to dial those numbers. The unfortunate reality, though, is that the courts really haven't been looking at that statutory definition. They've been looking at what the FCC had said regarding predictive dialers, and the current interpretation is that some courts are holding that any equipment with the capacity to dial numbers without human intervention is an ATDS. So it's a pretty broad standard. They've kind of written out that random and sequential number generator language and replaced it with this concept of human intervention, and that all stems from some FCC guidance in the past. Importantly, though, based on that word capacity being in the statutory definition, the focus really is on what your equipment, what your system can do. It's not necessarily the manner in which you're making calls. So you could be manually dialing calls, but if it goes through a system and you're using a system that has the capacity to auto dial, that's going to be considered to be an ATDS. One-touch dialing, our interpretation is that it's okay. There's some case law out there that supports that. The FCC has said in the past that speed dialing is not subject to the ATDS provisions. So that's some good guidance we have as well. So we do think it's okay, but it really comes down to the capacity of your system. The next issue is, well, what does capacity mean? And our interpretation has been, and the vast majority of courts have determined that the relevant inquiry is what is the equipment capable of doing at the time the call is made? What is its present capacity? And they have not looked to, well, it could do this if you modified it by doing X, Y, Z, by reprogramming it, by doing something else. That's kind of how there's been, 4 or 5 different courts at least that have reached that standard, and that was the conclusion that they came up with. What threw us for a little bit of a loop is this curveball out of the Southern District of California from July, and it's the Sherman v. Yahoo case that you see right now. Very, very high level. I don't want to bore you guys with the facts, but basically Yahoo is using a system that would get a phone number in related to its instant messaging service, and it would automatically send a text out under certain situations. So there was really no dispute that it could automatically send text, but there was a dispute on whether it could randomly or sequentially dial numbers. And so they were trying to point to that statutory definition and say, this is the standard that's in the statute, this is what we should go by. We do not have the present capacity to do that. But one of their representatives testified that they could modify the system, they could reprogram it, and then it would have that capacity. So the court could easily have just said, well, it doesn't matter, this future versus present capacity issue does not matter. It's auto dialing based on what the FCC has said, that's an ATDS, and kind of dispose of the case that way. But instead what they did is say, well, we think that actually both present capacity and future capacity is relevant. And you're saying that it could be modified in such a way. Therefore, if that's true, your system could potentially be an ATDS, and we're not going to dismiss the case as Yahoo was trying to get accomplished. So they rejected the present capacity standard that had been adopted by other courts. I will stress that this is the minority opinion. This is, the first case that's really specifically held this. I'll also point out that, in my view, they're relying on some questionable interpretations of Ninth Circuit opinions. So they pointed to 2 Ninth Circuit opinions, one Satterfield and another is Meyer, and they're saying that they stand for the proposition that it's present or future capacity. I don't agree with that. The Western District of Washington, which is also under the Ninth Circuit, meaning it's also bound by what the Ninth Circuit says. It has to follow the Ninth Circuit. It also agreed that those cases did not stand for what this Sherman v. Yahoo case is standing for. So I think it's kind of an outlier right now, but just know that it's out there. I'm going to talk a little bit later about maybe, kind of the impact of that and some thoughts on that. But right now I'm going to move on to prior express consent. So if you are using an ATDS, we are using an ATDS at this point, and we're making a non-telemarketing call, this is the standard that applies. The TCPA itself and the FCC's regulations, they don't define the term. There's no definition there. But fortunately, a long time ago, the FCC had held that, subject to a few limitations, which we can talk about, but when a consumer provides you with their phone number, that's consent to call them for a non-telemarketing call, unless they tell you otherwise, unless they provide some type of instruction that they didn't want to be called at that number. And in the context of debt collection calls, the FCC has limited it to you needed to provide the number as part of the transaction that resulted in the debt. So it has to kind of be, a natural flow from why they provided that phone number. But that's been kind of the standard for quite some time now. There's been a few different FCC orders that, came to that conclusion. The courts have almost all deferred to that. There's, something out there called the Hobbs Act, which basically says that district courts are required to follow FCC guidance. And all the courts have done that except for this one, the Southern District of Florida, which last year, as many of you know, reached an opposite conclusion. So it said that just providing your phone number is not sufficient consent for a non-telemarketing call. You have to actually verbally say something or in writing say something. That case is being appealed right now. I think that has a pretty good chance of being overturned. The FCC has weighed in, and its opinion is that the Southern District of Florida did not have the authority to challenge its orders. So I suspect that we may get some favorable rulings on appeal there, but that's just my speculation. So that's kind of where we've been. That's nothing new, but there have been some recent developments I think that are worth talking about. I wouldn't say that they're game changers, but they're kind of little nuances that are important and things that we need to think about. The first is this Walgreens case from July. And basically what the plaintiff alleged is that, okay, yes, I provided Walgreens with my phone number, but I did that only because they said they needed it for verification purposes. And what that meant by that is there's two Nick Whistlers that go into a Walgreens and I want to pick up my prescription. They would use my phone number to differentiate between the two different people with the same name. And then I started receiving calls that were about refill reminders and other types of marketing-related calls. I didn't provide my number for that purpose, therefore, I didn't consent to those. Well, the district court originally said, well, you provided your phone number based on what the FCC said, that's consent. The plaintiff filed a motion for reconsideration, and the court actually vacated its original opinion and said, we got it wrong the first time. We think that when somebody provides their number, the context is important. So the scope of the consent that they're providing by giving you their phone number depends on the context and the purpose for which they're giving you the phone number, for which they're giving you the consent. And that consent for one purpose does not equate to consent for all purposes. So it's just kind of limiting the scope of consent. It could also be viewed as an instruction to the contrary. I'm only giving you my phone number for this purpose, therefore it's not consent for everything. So a little bit of a nuance there, a little bit of a different interpretation. They obviously vacated their original opinion, and it's kind of narrowing that scope of consent a little bit. A very similar opinion was provided by the FCC a few months ago as well, and this stems from a case that has been appealed to the Second Circuit, and the Second Circuit asked the FCC for guidance. And what they said is the district court said in this case, you, plaintiff, provided your phone number to the defendant, therefore you consented to be called. But the facts are kind of a little bit interesting. The facts are the plaintiff was trying to get his deceased mother-in-law's electric service turned off. And as part of that, he gave the phone number to the provider in case there was any follow-up communication, et cetera. It turned out that the mother-in-law owed money, and they started making debt collection calls to his cell phone. And what the FCC said is, our orders in the past, we had a 2008 order that specifically dealt with debt collection calls, said that you needed to provide it during the transaction that resulted in the debt. That was not what happened here. The transaction was with the mother-in-law. There was no number being provided during that transaction that related to the plaintiff, because his phone number was only provided later to shut off the service. So that's nothing really new, but again, that they focused on the scope of consent is based on the facts of each case. So again, a little bit narrowing of the scope. There are some benefits of this, which I'll talk about here at the end, but they're kind of just really saying you need to look at how you're obtaining numbers and what scope of consent is being provided. The last prior express consent case I want to talk about is this Satori case. It's a circuit case, so it's an appellate court above a district court. Basically just upheld the FCC's debt collection rulings. Nothing new there. It is nice to get a circuit court to do that, but nothing new. But I do think it's kind of important to point out that they specifically rejected the plaintiff's argument that you not only need consent to make a non-telemarketing call, but you need consent to use for an auto-dialed call. You need consent to make a pre-recorded message. Those things must be specified above and beyond just a call for a non-telemarketing call. And the court rejected that under the prior consent standard. They said there's nothing in there that requires you to get that level of specificity. That's different from the new rules for written consent. So I just want to make that clear. You do need to specify pre-recorded message. You do need to specify auto-dialed calls when you're getting consent for a telemarketing or advertising call, text, pre-recorded message, what have you. But for a non-telemarketing call, you do not. And this court kind of upheld that position. So that was good. The other thing we're seeing a lot of right now are cases related to reassigned numbers. So basically, I am trying to reach one person that maybe provided consent, whether it's consent for a marketing call or consent for a non-telemarketing call. But what happened is I tried to reach that person. I ended up reaching another person because the number had been reassigned. And the issue comes down to, well, who's the called party? You need consent from the called party. So who is the called party? Is it the person that you actually reached, or is it the intended recipient of the call who you tried to reach? Courts are a little bit spread out on this one, but I can tell you that the majority opinion is that it's the current subscriber. So it's the person who actually received the phone call is the called party. And there's two circuit courts that have reached that opinion, one of which was earlier this year. The 7th Circuit in 2012, and then the 11th Circuit this year had reached that. There was a case actually that came out on Monday from a district court, not in either of those circuits, that said it was actually the intended recipient is what called party means. But that's the minority opinion. The majority opinion is the current subscriber. So, it's kind of a problematic issue, right? Because there's no way to determine for certain whether a number's been reassigned. I think there's some services out there that you can use to help, give you an idea, but it does create a compliance challenge that you can't definitively know. So along those lines, there are several petitions pending before the FCC asking for relief. They want some type of safe harbor or some type of interpretation that would not expose them to liability for a call where they had proper consent, except for the fact that the number had been reassigned and they didn't know that. PACE, actually, we filed a comment in supporting those petitions on behalf of PACE. Lots of other companies and associations did the same. I don't know that we'll get anything definitive from the FCC on that anytime soon, but just know that that's kind of out there. But the one good takeaway, though, is that some courts are starting to stay cases. So the defendants are saying, don't rule on this case until the FCC provides guidance one way or another. And so they're kind of shelving those cases for the time being, which I think is a good result in the short term. So that's kind of like what's going on. As far as takeaways, number one, you really need to strengthen your policies and procedures for high-risk areas. Number one would be calls to cell phones, texts to cell phones, pre-recorded messages for anybody left doing that. That'd be another high-risk area. But you really need to make sure you have good policies and procedures to make sure that there's some, fail-safe mechanisms there to prevent unintended violations, to make sure you're on top of the law, you're continuing to monitor what's going on, and that you're adopting your policies and procedures to counter those developments. The other thing is, you might take a conservative position on what is an ATDS in the Southern District of California. Again, I don't believe that was the correct interpretation. I'm hopeful that at some point in time we could maybe get clarification from either the FCC on the capacity issue, because there are petitions pending before it on that issue as well. Or maybe the Ninth Circuit, which would be the appellate court for that district, would maybe overturn it. But until then, there's a little bit more risk in that calling into that district or from that district than maybe some other districts. So just kind of keep that in the back of your mind and really just make a business decision on what you want to do there. Also, you need to make sure you have proper consent for these calls. So are you meeting all the written requirements for the written consent rules? I didn't go over all of those. I touched that at a very high level, but happy to follow up with you offline if you need some assistance there. I know we've talked about that quite a bit in the past, though. And then non-telemarketing calls, what I take from all these recent cases is you really need to know, where do these numbers come from? What did they provide it for? What was said to them at the time the number was obtained? Was it, are you saying that you're going to use it for a limited purpose? Because if so, your consent to call them may be limited as well. Really take a look at that and try to be as broad as possible when you're getting those phone numbers, so that the consent provided is as broad as possible. But the one impact of those decisions that I mentioned earlier that I was going to talk about relates to class certification. So I don't want to get too deep into the weeds and legalese about what that means, but at a high level, there's certain requirements that you need to meet in order to bring a class action, in order to get it certified as a class action. And one of those, actually two of those, are numerosity, meaning there's lots of different people that are in the same situation as you are, and typicality, meaning that all of you are in, your claims are all the same. Everybody kind of went through the same experience. And courts have held that if you need to, look at an individual by individual basis on any type of fact-checking inquiry or something like that, those types of cases are typically not right for class certification. So all of these cases saying you need to look on an individual by individual basis at the scope of consent. How was the number provided? Who was it provided to? What was said? That's kind of hard to show that you had the consent, but it does mitigate risk potentially, because it may be harder for these plaintiffs' attorneys to get the lawsuit certified as a class action. And what that would mean is that instead of settling for calls made to 100,000 people, you're settling for calls made to that one specific person. So obviously the dollar amount would be significantly less. So it's kind of a procedural type of thing. There's kind of pluses and minuses from those cases, but to the extent that we can make it harder for somebody to bring a class action or get it certified, that's a good thing for us. One caveat to that before I wrap up here is that class certification issue sometimes takes a while to resolve, so you may end up spending a significant amount in attorney's fees fighting the case even before you get it to a point where you decide, can this be maintained as a class or not a class action? So, not a saving grace, but there is some silver lining there, I suppose. That's really all I wanted to talk about today. I'm happy to answer questions at the end of the presentation. Just kind of an FYI here, we do have a TCPA blog on our website, so there's some instructions here on how to do that, but it's a great way to stay up to date on some of the case law that's being handed down. And as I said, I'm happy to answer any questions later.
Thank you, Nick. Our next presenter is Jeff Mina, CEO of Connect First on TCPA and PCI Best Practices for Contact Centers. CEO of Connect First, Jeff leads the company's strategic direction and is also the primary architect of the Connect First platform. He has taken the product through 4 generations in a desire to develop the most feature-rich, highly scalable, fault-tolerant, and secure cloud-based contact center solution on the market. Welcome, Jeff.
Thanks, Lisa. Greetings, everyone. I'm just going to take a couple of minutes here to talk about some best practices. At Connect First, we deal with TCPA and PCI on a regular basis for our customers. So we've got a pretty long history helping people navigate through some of these things. First item here, definitely good practice to always consult with corporate representation. As you just heard from Nick, TCPA is very complex. Most individuals without legal background are going to have a lot of trouble interpreting this legislation and understanding how it exactly applies to how you operate your contact center. Everything from how you're attaining your lead lists to the ATDS platform you're running on, all of that is very complex, and working with somebody like Nick or other subject matter experts will really help mitigate the risk. The second item here is, I mean, it's just a no-brainer. The DNC registry has been around since 2003 and is one of the most common sources for class action lawsuits. I saw a question pop up earlier. Most of the best-in-breed SaaS-based or cloud-based contact center platforms will provide interfaces directly integrated into the national, state, and cellular do not call lists. So signing up with the right vendor should help take care of a lot of your do not call registry, a lot of your cellular scrubbing, and just general list management and sanitation requirements that you're dealing with. And this goes back, the third point here really goes back to something else Nick was talking about, having really strong policies and procedures around how you manage your internal do not call lists, how you manage your lead data in general, having that documentation and actually adhering to the policies and procedures not only really mitigates the chances that somebody's going to file a complaint against you, but if it does happen, it really creates the best defensible position for you to go to court and prove that you did not act outside of the TCPA. The outbound solution piece, that's really a vendor selection component. You need to spend a lot of time vetting your vendors, having your corporate counsel vet your vendors. There's a lot of dialer companies out there that may claim that they have a TCPA compliant solution, but whether that holds up in court or not is really something that you can't know unless you properly get in there, get under the hood, ask them for their documentation, preferably have a third party refer, a third party attestation that they have looked at their technology and it's within the letter of the TCPA, and specifically what you're looking for is that the infrastructure does not have the capacity to dial without human intervention. That goes back to the definition of the ATDS Nick was talking about. The compliance and training programs, you can pick the training programs, you can pick the best technology, you can choose the right vendors, you can make sure your management team fully understands TCPA, but if your contact center agents don't understand it and they are updating your CRM and potentially putting in alternate phone numbers and then those are being fed into your dialer, you could inadvertently fall outside of your procedures and end up in a court battle when it was just an agent who didn't understand what they needed to do and what questions they needed to be asking. So the PCI Security Standards.org website has a ton of information. It's probably more than any single person wants to read in a day. Folks like Jeff Brown at Compliance Point have spent years understanding all the requirements, but it's a really good starting point to get in there and start to get a picture of what taking your organization from non-PCI to PCI compliant will look like. If your organization doesn't have a compliance officer, then you really need to bring in an outside party. It's just, there's so much and so many details and technical nuances and specifications, covering how you build your networks, how your computers are set up, how your computers are secured. It's a tremendous amount of work. And folks like Compliance Point working with your technology vendors gives you the highest probability for success in actually getting that third-party attestation and making sure that you're within the PCI guidelines. All of your technology vendors need to be part of this process. Your order management system, your CRM, your network vendors, your contact center, platform vendors, your outbound dialer, your inbound ACD, your IVR, all of these folks need to be brought into the mix, and they all need to be working together, and individually they need to be able to support PCI service level status. So it's a lot of coordination, and it does take a lot of time. So one place people get into and they realize they've got a major problem they need to overcome is with physical layout. Physical security and how the networks are actually run, you know, where your physical machines are that need to be secured. You know, obviously they can't be sitting out in the middle of your call center. So there's a lot of planning that should go into place even before you build out a contact center, or if you have one, be prepared to actually restructure some things, provide the physical security, provide the physical network security that you need to ensure that you're going to be able to successfully get a third-party attestation. The modern contact center is really going to be required to take a hard look at work-at-home agents if they're working in any type of space where they have a lot of scale up and scale down activity. It just doesn't make sense to have an extra 100,000 square feet of empty desk space when the technology exists to support an at-home workforce. The at-home workforce and PCI is a challenging combination, but it can certainly be done. Some of the biggest BPOs in the world have huge work-at-home staff, and they're fully PCI compliant, and you hardly ever hear about one of those guys having a breach of security. So it is possible. It does take some work, but ultimately it'll pay off. So I guess the best overall advice I can give anyone concerned is to engage subject matter experts early in the process. Neither TCPA nor PCI is simple to operate a business within, but the payoff in the long run is definitely worth it, and you'll see big ROI in time and lack of spending on defending yourself in the courts. That's it, Lisa.
Okay, I'd like to thank you all for joining us today. Thank our presenters, Jeff Brown, Nick Whisler, Jeff Mina. And thank you, Connect First, for a great webinar. This webinar will be posted as a link on the PACE website and also be given to Connect First to share with all of you attendees. Thank you again and have a great afternoon.